Started.
Good evening, friends. Myself, Rishikesh, Vyas, on and behalf of Udan Saluters, welcomes you all. It's our privilege hosting you all for today's session. Government orders on payment of wages and salary by private sector, validity and challenges. We have today amongst us Mr. Anirudh Deshmukh, Advocate Supreme Court, who happens to be rising star in the galaxy of legal world and one of the brightest. Before introducing him, I deem it fit to pose some questions to all of us, which are very relevant for the subject in hand. Are private sectors bound by the government dictates? What is the law of land in the matter? Has the Constitution of India any role in the matter? The subject matter itself quite complex, as within its ambit can be covered wage, that is for the blue collar workers, salary for the white collar workers, and the contractual staff. Does the company have to contemplate on certain aspects and ring fence itself before implementing any decisions? As we are in the period of annual review of the operations for the financial year, will it have any impact on the overall stand to be taken by the company? Does the private sector have to beg, borrow, and steal in order to make good of the compliance for the government orders? Why government itself is cutting salaries is also one of the very pertinent and the relevant questions. Now, as key issues have been put before you all, let me take this opportunity in introducing our esteemed speaker for the day. Anirudh Deshmukh is an advocate and record in the Supreme Court of India. Anirudh is a graduate from the prestigious National Law School of India, University, Bangalore. He has over a decade rich and assorted experience in the legal matters, and areas of practice and specialization include constitutional matters, commercial laws, indirect taxations, company insolvency law, competition law, in addition to the arbitration and the direct taxation. He has been involved in some of the key legal cases, which I deem it fit to bring to your notice. Suresh Ganpati Halwankar versus State of Maharashtra. This is a landmark judgment under the electricity law, whereby the judgment of the Supreme Court was regarding the compounding and quashing of the discrete offences under the Electricity Act. Rasiklal Kantilal Company versus Board of Trust of Port of India. This was in relation to the shipping and the marine law. Forbes Campbell versus Board of Trust Port of Bombay. Again, it was under the infrastructure and the shipping laws and the liability thereto. State of Maharashtra versus Atlanta Limited under the Arbitration Act. Salora International, it was in relation to the excise and the custom classification. Vishal Pandey versus Hero Honda, it was the competition law and the first investigation by the CCI, that is the Competition Commission of India, into anti-competitive actions of the two-wheeler manufacturers. Karnataka Phil Chamber of Commerce versus Kannada Graha Kota, competition law confirming of the orders of CCI that banned the dubbing is an anti-competitive activity. If the time permits, we shall be taking your questions, which you may post direct accordingly. Or in an alternate, you may just email it to us at udansaluters@gmail.com. Mr. Deshmukh, now the session is all yours.
Good evening, everyone. Welcome. I was a little surprised when Mr. Vyas said we'll be talking for 2 hours, and I was wondering as to what he's offered as bribe to the participants to sit with us for this long. And I really hope that you find the session interesting. It's bound to be informative for you as well as for me. I wish to learn from your questions, share a practical viewpoint, and sort of figure out where we stand today in terms of the law, in terms of the legal appreciation of the law, as well as how I expect the Supreme Court to finally hand down its decision on this particular issue. Let me start by introducing the topic itself. The topic has been circulated to everyone, but how I would look at it is very simplistically, is whether the government of India, in exercise of its powers under the various acts, can it really compel the private sector to pick up obligations which the private sector would otherwise not wish to do. And that quite frankly boils down to whether a private sector undertaking can be compelled to pay its workers and employees wages and salaries during the period of lockdown that we are currently facing. The essential issue arises because the private sector has been fairly liberalized and enjoys certain rights under, say, the Constitution of India, or even otherwise, to resist governmental action. And that is the sort of backdrop in which I will be positing today's seminar and trying to learn from you and sort of presenting my thoughts on that issue as well. Just to sort of break down how I'll be speaking on the separate topics. First, I would like to deal with the jurisprudence behind the law itself, whether this is a moral obligation, whether this is a legal obligation. Can the law itself be framed in such a manner so as to direct certain compliances? The second part of the talk will then focus on the power of the government itself, as to where does it derive all these powers to compel private parties to do certain acts. And the third part then, of course, will deal with the legal challenge and on what basis will be the legal challenge mounted before either the High Court or the Supreme Court, and what are the grounds that one must plead really to make good their challenge. I would lastly then sort of briefly touch on the pending litigation that is going on in the Supreme Court of India and update you all on where I expect that litigation to go. So without further ado, let's get started. But before I start, I just wish to refer to a few resources which all of you can either open on a screen next to you. I'll attempt to share my screen, of course, but this primarily will be the Disaster Management Act. It's available on India Code. It's updated. It's the version I'll be referring to. And secondly, if you can open the NEC, that is the National Executive Committee Advisory, which is available on the NDMA website, because I will be referring that advisory in extenso as well. So let's get started. Let's sort of start with what we are dealing with really. What we're really dealing with are two separate advisories. One is an advisory, one is an order of the Government of India issued by two separate ministries. The first one is dated the 20th of March 2020, which was by the Ministry of Labour. This, in fact, has been in three separate parts. One was by the Secretary of the Ministry of Labour, which prescribed that there should be no termination, particularly of casual or contractual employees. Secondly, there should be no deduction in wages. And consequently, an advisory was issued on that basis. On the same day, the Joint Secretary of the Department writes to all employees, including public and private, stating that there should be no termination and there should be no reduction in wages. A little missed advisory in this whole chain is the second advisory, as we call it, dated the 23rd of March, which was again released by the Ministry of Labour, which was significantly to the Urban Affairs Ministry. And this came reiterating what had been said on the 20th. Now, the first thing we need to note here is that the DM Act itself, which is the Disaster Management Act, has been invoked only on the 24th of March. Therefore, these directives or these advisories by the Ministry of Labour predate the invocation of the Disaster Management Act. And that is legally significant in a manner which I will come to in a little while. But let's just mark that as a date. that 24th of March was when the Disaster Management Act was invoked by the Government of India. Now, subsequent to the invocation of the Disaster Management Act, we've seen a series of orders which were passed. And the real order that we are dealing with today is the order dated 29th of March 2020. Now, this order has been released by the National Executive Committee, which under the NDMA, which under the DM Act occupies a very special place as the overall implementing authority of the Disaster Management Act itself. Something that I will bring out during the period when I discuss the Act itself. So having given you the background of what we are dealing with today, the real issue is that on 29th of March 2020, the National Executive Committee, exercising powers under 10(2)(I) of the DM Act, has specifically stated that all employees will be entitled to receive their payment of wages. And that is really what has been challenged as a direction that is both ultra-virus the Constitution, which is beyond the powers of the NEC to give, as well as the enabling DM Act itself. So first of all, let me just sort of touch upon the jurisprudence behind lawmaking. When we discuss the law, there are different connotations, different perceptions that come in. Is it law merely because I've been told by somebody that this is law? Is this law because it is right for me to do it? Is it law because there is a moral obligation on me? Or is it law because I choose, or I can choose what the law is? Can I say that this is not law for me and hence not follow it? These are different ways that people look at the law. It's a very jurisprudential, very philosophical way of looking at what the law is. This can be broken down into 2-3 very broad questions. Is this a moral obligation of the employers? Is it a legal right of the worker? Can the law really prescribe this rigor on a private entity? These are the 3 broad questions that do arise when we look at such harsh laws. Harsh in the sense that they impose really onerous obligations upon parties expected to comply with it. Now, in this whole facet, we find something known as legal positivism. Now, legal positivism actually is a manner in which the law is understood. And very, very briefly said, I'd like to quote a Stanford encyclopedia on philosophy to just lay out what legal positivism really means. And it means the fact that a policy would be just, wise, efficient, or prudent is never sufficient for thinking that it is actually the law. And the fact that it is unjust, unwise, inefficient, or imprudent is never sufficient reason for doubting it. Now, in our case, I think the latter part of the aforesaid statement that reads that, and the fact that it is unjust, unwise, inefficient, or imprudent is never sufficient reason for doubting it holds very, very true. Because as private employers, we do chafe against any restriction or imposition of obligations by governments that we believe to be extraneous or beyond the power of the government. Now, if we were to say that in terms of legal positivism, is this order really law? Yes, it is. Because merely because you do not agree with the manner in which the law is being imposed upon you is not the sole reason for you to restrict its operation upon yourself. And that is something that we will have to keep in mind, because we do believe in the legal positivist theory in India. The courts also apply it. And that's where we really stand now. Now, having given you a very, very brief background on legal positivism, of course, there are many threads that discuss, there are also critics of the legal positivist theory. But let's just keep in mind that this is something that both courts in India and Indian legislatures operate upon, that we work within a positivist framework and that the legislature, central or state, reserves itself the power to direct citizens to act in particular ways or desist from acting in particular ways. Which then brings me to a subset of this particular topic itself, of legal positivism. And this is something that is, which I believe would be really helpful in determining the contours of our discussion. And it's a theory that goes back many, many years in the legal field. Many of you would have heard it. Those who are not from the legal background, we call this theory as hard cases need bad law. And that is something that rings extremely true in this case. And the natural question that then arises is, how does one really explain what hard cases make bad law really means. The Supreme Court of India has often referred to this doctrine that yes, hard cases do make bad law. And the simple answer is that, and of course this is not an original court, but a court from the Supreme Court of India, that extreme cases often test the bounds of established legal principles. There is a cost to yielding to the desire to correct the extreme case rather than adhering to the legal principle. That cost has been demonstrated so often that it is captured in the phrase, hard cases make bad law. And that is really what we are seeking to address today. The Government of India, in the order dated 29/03/2020, has sought to address the extreme case of people who were forced to go back to their hometowns because of lack of work wherever they were situated. It led to a really grave situation where many lakhs of people came down onto the road in a desperate attempt to get home. It tugs at our heartstrings, it tugs at our conscience, but can the Government of India, to address that extreme case, come up with a law that says that the private enterprise must pay? And that is exactly what I mean by hard cases make bad law. Applying this in the legal context, it would be in the following sense, and again, I would like to quote from the Supreme Court itself, is that the exercise of the power of moderation is to correct what we believe to be fair and impartial. The cases pointed out are hard cases, but hard cases cannot be allowed to make bad law. When we lean in the favor of strict interpretation or construction of the rules, what the Supreme Court is really trying to say is that if you're confronted with a case which is very difficult, you must sort of follow the rules of construction that would lead you to natural consequences, and not such rules of construction that would strain the language of the statute that has empowered the government to act. This also is very important, because when I come to the Disaster Management Act and I read it with you all in detail, it will be very evident that there are certain powers that the government does possess. It will also be extremely evident that there are certain powers that the government simply does not possess. And if the government does not possess such powers, is it within the realm of the court to then supply that omission in the statute and make it good, and then say, okay, very well, we do interpret that given that the government had X, Y, Z power, it also had A power or B power? These are questions that I will be answering. And therefore, before I come to the next section, for those who are interested in reading along with me, now would be a good time to sort of just open the Disaster Management Act, because that is where the powers of the NEC really flow from. I'm just going to give everyone a couple of seconds to open the Disaster Management Act. I'm going to do the same. I'm also going to try and share the copy of the Disaster Management Act that I'm going to refer to. I hope it's available to everyone. Now, proceeding to reading the Act, let's sort of understand that this was an Act that was passed in 2005. And I'm not going to go through all the sections in this particular Act. I'm just going to read a few sections, right? So that we know where we stand today. The first section that we really need to deal with is 2D. And it says, what is a disaster? Now, the Act says a disaster is a catastrophe, mishap, calamity, or grave occurrence in any area arising from natural or man-made causes or by accident or negligence, which results in substantial loss of life or human suffering or damage to and destruction of property or damage to or degradation of environment, and is of such a nature or magnitude as to be beyond the coping capacity of the community of the affected area. So whether the COVID-19 crisis qualifies as a disaster, yes, it does. There is absolutely no doubt about that. So let's just take that as the first building block of our argument. The second is subclause E, which says disaster management. Now, if you were to just run through what disaster management includes, one would see that these are essentially obligations that are generally to be exercised by the government. And nowhere is there a mention that you must be exercising these powers through the state. Now, let's come to the next section as to what is really the National Executive Committee, because the 29th March order is of the National Executive Committee. So Section 8 says that there will be a National Executive Committee under the Act. And it essentially lays down the constitution of the National Executive Committee. And then comes the most important part under Section 10, which is powers and functions of the National Executive Committee. Now, let's just read this very, very carefully, because the order of 29th March has been passed under this particular provision. So the source of the power, as we know it legally, flows from this particular section. So let's just take a minute to read it and then sort of explore the contours of the power that is really available to the National Executive Committee. So let's read the section. The National Executive Committee shall assist the national authority in discharge of its function and have the responsibility for implementing the policies and the plans of the national authority and ensure compliance of directions issued by the central government for the purpose of disaster management in the country. Now, subclause 2 reads, without prejudice to the generality of the provisions contained in subsection 1, the National Executive Committee may, and then it proceeds to read various other things, but I'm going to restrict myself to reading I, because that is what the government of India has really invoked in our case. And I reads as follows: evaluate the preparedness at all government levels for the purposes of responding to any threatening disaster situation or disaster and give directions where necessary for enhancing preparedness. Now, this really is a very, very interesting power that the government has, because if you see clause L now, it says lay down guidelines for or give directions to the concerned ministries or departments of the government of India, the state government and the state authorities regarding measures to be taken by them in response to any threatening disaster situation or disaster. Now let's just for a minute see I and L together. L makes it very clear that the authority can give directions only to state instrumentalities and not private parties. Whereas I, which the government would argue that gives powers to pass a direction even to private authorities, merely says give directions when necessary for enhancing such preparedness. Now the question would then necessarily arise as to do we know what preparedness really means? And the Act itself says what preparedness means, and that is on 2M, which I've come back to now, means the state of readiness to deal with a threatening disaster situation or disaster and the effects thereof. So let's ask ourselves the first question. Is a direction to continue to make payment of wages or salaries a measure of preparedness? I would answer in the negative. It cannot be a method or a measure of preparedness. Is it a method or a measure of rehabilitation? Perhaps, maybe. But that is a subsidiary question. If the government says that I'm invoking the power under 10(2)(I, and that power relates to preparedness, then we must question the government and the order on this particular basis, that whether you can actually invoke this power on this basis. Now, just while I am on this particular section, you can note that subclause P specifically says resources, and resources includes manpower, services, materials, and provisions. And this becomes important at a slightly later stage when I will take you all further through the Disaster Management Act. Now, having shown Section 10, the next provision that we must really deal with is Section 11, and that is the National Plan. And this is important because if you were to just open the website of the NDMA and have a look at the National Plan, it's extremely comprehensive. It deals with various disasters, including public health and biological disasters. And that essentially is the roadmap that the government professes to adopt in the face of a disaster. So let's see Section 11. There shall be drawn up a plan for disaster management for the whole of the country to be called the National Plan. The National Plan shall be prepared by the National Executive Committee, having regard to the national policy and in consultation with the state governments and expert bodies or organizations in the field of disaster management, to be approved by the national authority. Now, this in fact says, subclause 4 also says the national plan should be reviewed and updated annually. And in fact, it has been done for the year 2019, and it is still available. Now, the interesting part about the whole plan is that if one were to look at the annexures to the plan, which essentially weighed on public health or biological emergency, there is absolutely no mention of providing or making the private sector responsible for discharge of certain obligations of disaster management or disaster mitigation, which is very, very significant, because the government can stand up and say that, look, we have the power under 10(2)(I), because the national plan on which we are basing this has the power to rope in or direct certain private parties to perform certain acts or not. Now, that argument can only then be tested on the basis of the documentation that is available. Now, the next section that we must see is 30, which I will now come to, because it says powers and functions of district authorities. Now, district authorities are the absolute ground level authorities that help in disaster mitigation. Now, what does the district authority really have the authority for? It says that it has the authority to do all of the following. Now, let's look at 5. Give directions to different authorities at the district level and local authorities to take such other measures for the prevention or mitigation of disasters as may be necessary, and to monitor the implementation of disaster management plans prepared by the departments, and lastly, to lay down guidelines to be followed by departments of the government at the district level. Now, if also the power under 11 is sort of important, because looking at this is for the determine whether private parties can be put under an obligation. So let's look at 11. Review the preparedness and give directions to concerned departments at the district level or answer concerned authorities where necessary for bringing preparedness measures to the level required for responding effectively. Now, 13 says, facilitate community training and awareness programs for the prevention of disaster or mitigation with the support of local authorities, governmental or non-governmental organizations. Now, this is the first time we see that a power is being given to involve a non-governmental organization for community training or awareness. Now, does that really mean that you can then direct a private party to do a particular act? I doubt it. The rest of the powers of the district authority as well do not really seem to suggest that they have the power to rope in a private authority to do a particular act or refrain from doing a particular act. Now, the next section that I would like to refer to is 35. Now, what does 35 say? It says that subject to the provisions of this act, the central government should take all such measures as it deems necessary or the expedient for the purpose of disaster management. Now, again, you will see a list of powers that the government really has to discharge this particular function. And again, this does not seem to refer to any power that can direct a private party to do or refrain from doing something, because all of the powers really deal with either the state authorities, international authorities, or various other authorities of the government itself. But the government has passed this order under 10(2)(1). So then let's see as to where does that lead us. Now, the first issue is what happens if I don't follow the government order? And is there any offense that I would commit if I don't follow it? We'll come to the question of whether the order itself is illegal or not, but let's just assume that today the order exists. So the first principle that you must be aware of is that 51 very, very clearly says, whoever without reasonable cause obstructs any officer or of the central government in the discharge of functions or refuses to comply with any directions given by or on behalf of the central government or the state government or the National Executive Committee shall on conviction be punishable with imprisonment for a term which may extend to 1 year or fine. Now, this particular section is extremely important because it gives you a twofold right as such. It says without reasonable cause, if you do not comply with the order, naturally raising the question, If a particular enterprise or a factory or an establishment during the period of lockdown has absolutely zero earnings and is using its savings merely to, say, service its financial obligations or other obligations and has no money to pay to its employees or workers, is that reasonable cause? Can you demonstrate reasonable cause that, look, on facts, I genuinely do not have the resources to pay? I would say that that is an arguable case. That yes, reasonable cause is demonstrable within the scope of Section 51, and that every private enterprise must focus on ensuring that its documentation, that its books of accounts do reflect reasonable cause if genuinely available. For example, an extremely large company with a very, very large cash pile that it has in reserves may not be able to demonstrate such a reasonable cause. But what we are really seeing today is that it is not the large corporates which are really facing the issues, but MSME units, units that work on very, very small margins with small turnovers that are essentially the blood and the lifeline of our industrial processes which are facing issues today. So let's be very, very clear that 51 does require that the defiance was without reasonable cause. And that is something that we must keep in mind. Now, coming to the next provision, it's in miscellaneous. Now, what does miscellaneous really do? One would assume that miscellaneous is those provisions that are in aid of the main act. But surprisingly, reading the miscellaneous provisions of this particular act takes us to very strange consequences. And I'm going to take you all to that straight away, because we have 62 in the miscellaneous. Now, I showed you provisions that dealt with the power of the central government, that dealt with the power of the National Executive Committee. And one would assume that being given all these powers, why do you need something like 62? And 62 reads very interestingly. Because if you saw the previous section where I read the powers of the central government, it says subject to the provisions of this act, correct? Now, 62 on the other hand says notwithstanding anything contained in any other law for the time being in force. Now, this sort of gives this particular provision overriding power over all other acts. And what does it read? Notwithstanding anything contained in any other law for the time being in force, it shall be lawful for the central government to issue direction in writing to the ministries or departments of the Government of India, or the National Executive Committee, or the state government, state authority, state executive committee, statutory bodies, or any of its officers or employees, as the case may be, to facilitate or assist in disaster management, and such ministry or department, the government or authority, executive committee, statutory body, officer, or employee shall be bound to comply with such directions. Now, with respect to the power to direct a private enterprise to do a particular thing, which is payment of wages, I do not believe that even 62 provides the power to the government to say that you shall continue making payment of wages and that you should not terminate people, or that you shall deem that people are on duty despite them not attending to the place of duty because of the lockdown. Now, if 62 is the third basis of power that the government would wish to rely on, then it is my opinion that even 62 may not come to the rescue of the government in that particular situation. Now, let us come to 65, because 65 is an extremely interesting provision. It deals with the power of requisition of resources, provisions, vehicles, etc. for rescue operations. Now, as I just about 5 to 7 minutes ago asked you to make a mental note of what resources really meant. Now, let's just see. Now, what is requisition? Requisition means that the government, in certain cases of need, can direct the private authority to take up its resources, and of course, on the basis of compensation, if the act so permits, is requisitioning. So, for example, if there is a disaster in area X and there is a gentleman with a very large house which can be used as a hospital, the act does provide the government the power to requisition his house to use as a hospital. Maybe he has a lovely car that can go into really remote terrain. The government can requisition that vehicle to access that remote terrain for the purposes of providing relief to people affected by the disaster. Which is why 65, in my opinion, is the only repository of power where the Disaster Management Act can encroach upon private rights. So let us now read 65. If it appears to the National Executive Committee, and I'm going to restrict myself to the Executive Committee here because that's the one that has really passed the order. So let's read it in that way. If it appears to the National Executive Committee or any officer as may be authorized by it in this behalf that any resource with any authority or person are needed for the purpose of prompt rescue, any premises are needed or likely to be needed for the purposes of rescue, or any vehicle is needed or is likely to be needed for the purpose of transport of resources from disaster affected areas or transport of resources to affected area or transport in connection with rescue, rehabilitation or reconstruction. Such authority may by order in writing requisition such resources or premises or such vehicle as the case may be, and may make such further orders as may appear to necessary or expedient in connection with the requisitioning. Now, therefore, the section then says, in this section, resources includes men and material resources, services includes facilities, premises includes land, building, etc., and vehicle means vehicle. Now, let's ask ourselves a question. The government has the power to direct the private enterprise to be a part of rehabilitation, rescue, or relief. To what extent? To the extent that it is mentioned in Section 65 of the Disaster Management Act. Does the Disaster Management Act in Section 65 say that the government also possesses the power to direct any person, which would include the private enterprise, to continue to perform certain obligations that it would have otherwise had? Respectfully, no. It only says that if the government does wish to take over a private resource, it can take over private resource or pass certain directions for the employment of that private resource. And that power is extremely limited under Section 65. Now, this becomes very, very important when you see the validity of the order dated 29th of March. Because as you will see later on, arbitrariness of subordinate legislation or orders of the government of India also hinges on whether the government of India, when passing a particular order, has the power to pass that particular order. Now, of course, the government tells us today that they have passed that order under 10(2)(I), and that the authority is derived from the Disaster Management Act. And so if I, as a petitioner, I am to question the source of that power and say that it is arbitrary, I would naturally want to contend that very well, the Act does give you certain powers, but this particular power is not available to you under the Act. And if this particular power is not available to you under the Act, then of course this particular action of yours must fail on the touchstone of constitutional principles of reasonableness. And that's essentially where we stand with the Disaster Management Act. Now, before I leave the Disaster Management Act, it is very important to read 71 as well, because 71 deals with bar of jurisdiction of the court. And this is extremely, extremely important. And it reads as follows: no court, except the Supreme Court or a High Court, shall have jurisdiction to entertain any suit or proceeding in respect of anything done, action taken, orders made, direction, instruction, or guidelines issued by the central government, national authority, state government, state authority, or district authority in persons of any power conferred by or in relation to its functions under this Act. And 72, it says that Act will have an overriding effect, which essentially means that notwithstanding anything contrary to the Disaster Management Act, any order of the disaster management authorities will override those particular acts. Now, this is a very, very significant power of the government in times of national need. Now, let's just come back to 71 for a minute, because that leads you to a question of jurisdiction in terms of which court can you really approach if you feel aggrieved by a particular order. Now, certain companies, as everyone is aware, have chosen to approach the Supreme Court, which of course is permitted. Parties are also free to invoke the jurisdiction of their local high courts, because you cannot go in a suit or to a district court or a court lower than the High Court to challenge the authorities of the national executive. I believe that this has been done to ensure that the powers of the government are not unnecessarily questioned or tied up in long-standing litigation, but it also provides to the people wishing to question such action access to a constitutional court, which is always alive to far larger sensibilities than what a district court may be alive to, and also possesses far larger powers and the power to grant greater relief than what a district court otherwise bound by a particular statute might have. So this is a balancing provision, but must be kept in mind. I'm just going to stop sharing my screen at this point in time and come back to where we stand now. Now, I've shown you the provisions of the Disaster Management Act. I have attempted to demonstrate, using the provisions of the Act itself, that there is no such power to compel the payment of wages or salaries under the Act. There exists a power to requisition private resources, but subject to payment of compensation, and of course, only in those private resources that the Act permits you to requisition, and nothing beyond that. Now let us come to the next act that is really important, which is the Epidemic Diseases Act. It's a very short act, and that act has only powers to regulate movement, transport, and certain other ancillary functions to ensure that epidemics do not spread from one part of the country to another part, and certain powers regarding restrictions. It really doesn't have any power that authorizes the government to undertake such a measure. Now, having sort of given you this brief legal background of the Disaster Management Act, let us read the Government of India order dated 29th of March itself, because that's where we can sort of attempt to tease out the stand of the government that will be to support, and the stand of private parties to demolish that particular order of the Government of India. Now, let's read that order step by step, because it tells you a lot and it also hides a lot in terms of legal basis of challenge. Whereas in exercise of powers conferred under Section 10(2)(I) of the Disaster Management Act, the undersigned in capacity. Okay, I've been requested to share on screen. Just give me a minute to see if I do have it on screen. If I do, I will. Yes, I believe this is the one. Whereas in exercise of the powers conferred under Section 10(2)(I) of the Disaster Management Act, the undersigned in his capacity as Chairperson, National Executive Committee, has issued an order of even number dated 24th and addendum orders 25th and 27th to the ministries, departments of Government of India, state/union territory, and authorities with directions to implement lockdown measures annexed to the said orders for the containment of spread of COVID-19. Now, para 1 is extremely important because it tells you that the issuing authority is cognizant of the base of power and to whom the power can be addressed. And therefore, it says it's been done to governmental authorities only. Now, let's come to para 2. Whereas movement of a large number of migrants have taken place in some parts of the country so as to reach their hometowns. This is a violation of lockdown measures and maintaining social distance. Whereas to deal with the situation and for effective implementation of lockdown measures and to mitigate the economic hardship of migrant workers in exercise of powers conferred under Section 10(2)(I) of the Disaster Management Act, the undersigned in the capacity as Chairperson, National Executive Committee, hereby directs state, union territory governments, state, union territory authorities to take necessary action and to issue necessary orders to their district magistrate, deputy commissioner, and senior superintendent of police, deputy commissioner of police to take the following additional measures. Subclause 1 is understandable. So is subclause 2. What is really troublesome is subclause 3, and it reads as follows. All the employers, be it in industry or in shops and commercial establishments, shall make payment of wages of their workers at their workplaces on the due date without any deduction for the period their establishments are under closure during the lockdown. The next one says, certain other powers, certain other directions are given. Now, let us just look at the nature of these directions. We can understand one, we can understand two, we can even understand four to a certain extent, because that would, by some measure, be essentially a requisition. By saying that, look, if you are the landlord, I am taking over your premises to ensure that those who are living on rent are not being evicted. But does the power under the DM Act really entitle to give them a direction in the nature as has been given in 3? That is something that we will now examine. What does 3 really require? Be it in the industry or in the shops and commercial establishment, shall make payment of wages to their workers. Now, this leads to the first question as to who falls within the definition of the word worker. Is it everybody? Is it the blue-collar worker who, through his sweat and toil, sustains our economy? Is it the white-collar worker who, by discharging work of great skill, provide an extreme value addition to our economy? My answer is that this order is not meant to cover employees beyond a certain earning capacity. And I'll make good this argument by referring to certain acts. But just for a minute, let's just run with this argument. So, has the term worker been really defined? Is the question we must ask ourselves. And the answer is yes, in the Factories Act. Now, the definition in the Factories Act of a worker is very, very interesting. And it essentially only reads as follows. It says a worker is a person. Yes, worker means a person employed directly or by or through any agency with or without the knowledge of the employer, whether for remuneration or not, in any manufacturing process or in cleaning any part of machinery or premises used for a manufacturing process, or in any other kind of work incidental to or connected with manufacturing process or the subject of manufacturing process, but does not include any member of the armed forces. Now, if the word worker has been used and the word worker is defined under the Factories Act, the question naturally arises whether this particular definition as in the Factories Act is the only definition that would apply. I would argue yes, because it is assumed that if the government is using a particular term, the government is aware that the particular term has been defined in the laws of India. And therefore, the term worker having been defined in a particular way, I am confident that an argument can be made that the term worker must be given the definition that is available under the Factories Act. But let's for a minute step beyond the Factories Act. What about the Industrial Disputes Act? It says workman. But again, that definition comes with two very, very important caveats. That these people must not be employed in managerial or other positions and must also not be paid more than rupees 10,000 per mention. Similarly, if I look to the Payment of Wages Act, it says that the limit is 24,000 rupees per month. Therefore, regardless of what statute I would like to look at, the definition of worker must by necessity be restricted to a particular class. Especially when I read para 2 of this particular order, which says that large number of migrants has taken place. Now, essentially by reading para 2 with the definitions that I have in front of me, an argument can be very strongly made that yes, there may be an obligation to make this payment, but only to such of those people who are covered by the definitions of either the Factories Act or the Industrial Disputes Act or the Payment of Wages Act, and nobody else. This leads to the next question. Can private establishments therefore exclude those people who are not covered by the aforesaid definitions? So essentially anyone making more than 24,000 rupees a month is not covered by this? Perhaps so. It is entirely possible to state that those people who make more than 24,000 rupees per month are not covered by the scope of the order dated 29th of March 2020. Therefore, those establishments who have a large number of employees, say in different areas of economic activity, can rationally make a decision that these are certain people who are excluded from the scope of the 29th March order. A question would then naturally arise as to what happens to the millions of people who are now working from home? Now, let's be very clear. If people are at work, whether remotely, whether through teleconference or otherwise, they're deemed to be on duty. They're deemed to be working. Therefore, there's no question of whether paying him or not paying that particular person. The question arises as to those people who are unable to work from home for X, Y, or Z reason. And this, I am again restricting myself to those who are earning more than 24,000 rupees for the purposes of this particular phase of the talk. Uh, my understanding is that no, these people do not require to be paid anything more than what their contract of employment really states. Uh, if the contract of employment states that you are only liable to be paid, say, 1 rupee and everything else is a variable component, then the private sector employer can rightfully stand up and say that I will pay you only 1 rupee. And that is very, very important, because this goes back to reasonable cause under the DM Act and say that I have reasonable cause, and this is the reason, that because I have a contract of employment with this particular person, and this person is not covered by the category of 24,000 rupees per month or less. And this is exactly where we come to a particular legal conundrum. Now, the order, as I read to you and as you can see in front of you, is fairly vague. The question now arises is, can the court, when interpreting these particular provisions, provide a missing portion of this order by saying when the government of India used the word shall make payment of wages to their workers, it really meant everybody, because the words that have been used is industry, shops, and commercial establishments. So the scope of coverage is very large, but the object of the coverage, that is the worker, is that equally large as well. And to that effect, I'd just like to read a few lines from an old judgment of the Supreme Court in the case of D.N. Agarwal. It's 1992 AIR 96 for those who wish to note down the citation. And it only reads as follows. It is not the duty of the court either to enlarge the scope of the legislation or the intention of the legislature when the language of the provision is plain. The court cannot rewrite, recast, or reframe the legislation for the very good reason that it has no power to legislate. The court cannot add words or read words into it which are not there. Assuming there is a defect or an omission in the words used by the legislature, the court could not go to its aid to correct or make up the deficiency. Court should decide what the law is and not what it should be. And this is very, very important when a party is to mount a legal challenge, because the order says wages to their workers. Now, I have sought to tease out the definition of workers from the Factories Act, from the Industrial Disputes Act, from the Payment of Wages Act, and none of these acts cover the entire spectrum of employees as such. Employees, in my submission and in my opinion, subject to correction, of course, is outside the scope of this particular order of the National Executive Committee. And this, in the legal background, would assume a great significance, because you are now stating in challenge to this particular order that you do not have the power to pass this particular directions qua the private parties for a particular class. To simplify this argument, it would be that the government of India and the National Executive Committee does not possess the power to compel industry, shops, or commercial establishments to make payment of wages to such of their workers who are outside the definition of workers. And I'm taking a slightly liberal definition of workers to also mean workmen, because tomorrow, in light of the fact that this is essentially a beneficial legislation, it is legislation or an order to help people who have been left in an extremely dire situation. You do not wish to take a very pedantic or a very narrow view of the words used, but to the contrary, can you take an extremely wide view of the words used? Also is not advisable. Therefore, let us sort of assume that the government of India wishes to help those people who are affected as is very, very evident in Para 2. Now, I have already dealt with the advisories of the Labour Ministry dated the 20th of March. And those essentially are only advisories because, firstly, they are not couched in mandatory language. They do not come with a threat of criminal action for non-implementation. And of course, they have been passed much before the invocation of the Disaster Management Act on the 24th of March. Now, this brings me to the next question and the next part of the talk, which is there a certain amount of discrimination that is happening here? As we are aware, the governments of Telangana, if I'm right, and Maharashtra as well as Haryana have passed certain orders stating that governmental employees will either be paid in tranches or their salaries stand reduced or their DAs stand reduced. In fact, the government of India has also come up with an order regarding the payment of dearness allowance, which in fact forms a part of wages, which is very, very important to note here. That DA does form part of wages, and therefore, can I as a government employee say that, look, on 29th of March, you said all employers will make payment of wages and therefore you can't reduce my DA, etc., etc. That's a legal challenge that can be reasonably mounted by an employee of the government of the country. And therefore, this leads to a discrimination, in my opinion, that if on the one hand, the government says that private parties involved in these three fields should not deduct wages or should make complete payment of wages, is it open for the government itself to then say that I will act in derogation or abrogation of these particular orders? It does lead to a bit of a dichotomy. It leads to a situation where you can reasonably say that this is a violation of Article 14 because you are prescribing one standard of operation for private persons and a completely different standard of operation for governmental authorities, despite the fact that people are working. People are working in the government, people are working in the private sector, merely because someone is working in the private sector is entitled to, I'm forced to pay his wages, whereas someone who works for the government will receive deferred wages or a deferred dearness allowance. So these are questions that would have to be raised before the court. And these are also questions that go to demonstrate what we really know as arbitrariness in governmental action. This whole talk has been really to set up the basis of arbitrariness in challenging the measures. Everyone here would be really interested to see as to how do we challenge it? How do we go about it? It's very well for you to tell us, this is what the law says, this is how the law is interpreted. But let's come down to the brass tacks. Why don't you tell me, if you were my lawyer or if I were to engage a lawyer, how would he go about challenging this particular act? And for that, let's now sort of first understand the principles that govern legal challenges to legislations. Our country has a long and cherished judicial history of the courts always acting as a check on the power of the executive. The court has the power to review actions of the legislature and the executive and then determine whether they ought to stand or fail. We have had a long history where courts have stood up firmly against actions that have been demonstrated to be in violation of either the fundamental rights of parties or in violation of the laws under which such action has been purported to be taken, or for various other reasons. The question, therefore, we would firstly have to answer is, what is this particular order? What sort of law is this particular order? It's been passed by the chairperson of the NEC, which is the National Executive Committee. He is passing an order under the Disaster Management Act. Now, is it a rule? No. Is it a regulation? No. Is it an order? Yes, very, very clearly it's an order. Therefore, at best, we can say that this is executive instructions, or at the outermost, a form of delegated legislation. Now, delegated legislation, very briefly, essentially means that having laid out the broad parameters under, say, the Disaster Management Act, for actual implementation of provisions of the Disaster Management Act, different officers or departments of the government are given the power to bring it into effect. For example, in this case, that if you find migrants on the roads, please provide them with certain facilities. If you find migrants in distress, please provide them with food and water. If you find migrants who are unwell, please provide them quarantine, health facilities, etc. Because it's very difficult to define when you're passing an act as to what particular situation the act might be required for. So let's just assume that this order also falls within the broad category of what we know as delegated legislation. Is there any way we can challenge it? Yes, we go to the court and we say that this particular act of the government of India or the state government, because both Maharashtra and Haryana, if I'm right, have passed advisories in a similar light, directing that payment of wages should be made. It should be made by a certain date as well. So we can go to court and challenge it, saying that, look, this infringes my fundamental right. And the violation of my fundamental right is in fact the ground on which the court will then take up the measure of the government for review. So let's just firstly see as to who is likely to approach the court. If you're a sole proprietor who runs a business, if you are partners who run a business, if you are the director of a company who runs a company, or you are an incorporated entity otherwise, say under the Societies Act or the Trust Act or in some other manner, what rights do each of these persons enjoy under our constitution to challenge the laws? So let's firstly delineate the fact that there are natural persons and there are juristic entities. Juristic entities do not enjoy the same basket of rights that citizens or persons who are alive and physical persons enjoy. For the reason that if you were to look at the Constitution of India, Article 19, which includes the right to do business, is restricted only to citizens and is not available to incorporated entities. So how does one go about challenging? Because this is effectively hampering the right to do business of a corporation. It provides a significant legal roadblock to raising a challenge. But the saving grace is in the fact that Article 14 doesn't prescribe a standard as to who can invoke it. Article 14 reads to provide the guarantee that there shall be no discrimination and everybody is equal, and that governmental action shall be equal for all classes. So there are different questions. A sole proprietor or a partner can reasonably stand up and say that I am claiming rights under 14 and 19. But if a company were to go to court and say I am claiming rights under 14 and 19, a reasonable question might flow down from the court as to very well, your right under 14 is understandable because you claim discrimination or arbitrariness in governmental action. But what about 19? Because as an incorporated entity, you are not a citizen of this country. You are owned perhaps by citizens of this country. Your directors might be citizens of this country. Your shareholders are citizens of this country. But you as the petitioner are not. And therefore your action before this court must fail. So to this particular effect, let's just trace the evolution of law. Because before you step into the court of law, you must be very, very clear where you stand. And in legal terms, this is known as locus standi, to challenge particular action. And rules of locus standi must be understood very, very clearly, because you do not wish your action to fail merely because you were not aware that you're not entitled to challenge, or that perhaps you were entitled to challenge and you did not challenge. So to that extent, I'd start with the latest position of the law and then take everyone back a few years, a few decades, to show how the rules of locus standi have really, really evolved. The first judgment that I will be referring to is a judgment rendered on the 6th of March 2020 in the case of Indian Social Action Forum versus the Union of India. I possess the civil appeal number, which is 1510 of 2020. For those who are interested, the judgment is available on the website of the Supreme Court. You can plug in the civil appeal number and read the judgment at your leisure. For the purposes of this discussion, however, I am only going to restrict myself to a couple of paragraphs to determine whether the Article 19 right is really available to incorporated entities, and then sort of work backwards from there. Para 15 of this particular judgment reads as follows. We find force in the objection taken on behalf of the Union of India that the appellant organization is not entitled to invoke Article 19. No member of the appellant organization is arrayed as a party. Article 19 guarantees certain rights to all citizens. The appellant, being an organization, cannot be a citizen for the purpose of Article 19 of the Constitution. See State Trading Corporation and Commercial Tax Officer and Bennett Coleman. In the absence of any member of the association as a petitioner in the writ petition, the appellant organization cannot enforce the rights guaranteed under Article 19 of the Constitution. Now, this judgment, which is rendered as recently as 6th of March, makes it very, very clear that as an incorporated entity or an organization, you're not entitled to invoke the provisions of Article 19. Therefore, you cannot say as an organization that the direction for payment of wages has now affected my business so adversely, and hence that is the ground for challenge. I do not believe that that sole challenge will be successful. You would also have to raise the challenge under Article 14 and say that this particular order is so discriminatory, arbitrary, that it affects me under 14. And yes, the moment you establish the right under 14, an organization can maintain that challenge. And I will come to that immediately by referring to the next judgment, which is the workmen of Meenakshi Mills versus the management of Meenakshi Mills. For those who are interested, the citation is AIR 1994-2696. It's a fairly well-reasoned judgment. And it's given that it's 1992, it comes on as a culmination to the development of the laws in the 80s regarding the fundamental right litigation. And just a few passages of this are necessary to read. And I'm going to read them for everyone's benefit so that we know where we stand. And they read as follows. Shri Garg has submitted that the employers in this group of cases are all companies registered under the Companies Act. A company, being an artificial person, is not a citizen, and it cannot claim the fundamental rights guaranteed to citizens under Article 19 of the Constitution. Reliance has been placed on various decisions of this court wherein it has been held. The rights under Article 19 are available to citizens who are natural persons and are not available to juristic persons as they're not citizens under the Constitution. It is also submitted that the shareholder of a limited company cannot be permitted to challenge the validity, inasmuch as by the impugned provision, none of the fundamental rights of the shareholder is impaired. Referring to the changed role of the shareholder in a modern public company, it has been pointed out that the shareholder, although a member, is in economic reality a mere lender of capital on which he hopes for a return, but without effective control over the borrower. Now, how does the court go about answering this very, very powerful argument seemingly on first blush? It proceeds to answer as follows. In view of the fact that some of the grounds for challenging the validity of the section are also on the violation of Article 19, can also be made the basis for challenging the ground of violation of Article 14. We do not consider it necessary to go into the question whether the right to retrench workers is an integral part of the right of the employer to carry on business. Now, therefore, this provides a very, very important clue. Now, let me just pause here and give you the background of Meenakshi. Meenakshi challenged 25N of the Industrial Disputes Act. And in that light, it was contended that 25N, which laid down certain restrictions, was violative of the right to conduct business under Article 19, 19(1)(g) specifically. And in response, the Union of India said, very well, it may be, but as an organization, 19(1)(g) is simply not available to you. But the court answers that, look, if the facet of the challenge under 19(1)(g) also incorporates certain challenges that are maintainable on the basis of Article 14, then the petitioners do have locus standi. There is yet another clue that is available in this particular decision, that where it particularly reads that since no shareholder has been made a party, the action ought to fail because the only person challenging is the organization. And to answer then this particular question, we go back to the celebrated case of Rustomjee Kawasji Cooper, which is very, very popularly known as the bank nationalization case, wherein the Supreme Court very shortly dealt with this question and said in the following words. I will first read out Prasenji Kagazji Kupa for everyone's benefit and then sort of place my interpretation on that. And it simply says as follows, and very, very quickly it says that as follows. The petitioners claim that by the Act and the Ordinance, the rights guaranteed to him under Article 14 and 19 are impaired. He says that the Act and the Ordinance are without competence in that they interfere with the guarantee of freedom of trade and are not made in public interest. And the Parliament has no legislative competence to enact the Act, and the President has no power to promulgate the Ordinance. He says that in consequence of the hostile discrimination practiced by the state, the value of his investments in the shares is substantially reduced. His right to receive dividend from the investment is seized, and he has suffered a great financial loss, and he is deprived of the right as a shareholder to carry on business through the agency of the company. The court then proceeds to answer the following claim as follows. It says that the Constitution in this court is opined that the corporation, not being a citizen, was incompetent to enforce the rights guaranteed under Article 19. Nor does the judgment in Tata Engineering have any bearing on the question of these petitions. In a petition under 32 of the Constitution filed by a company challenging the levy of sales tax by the state of Bihar, 2 shareholders were also included as petitioners. It was urged on behalf of the shareholders that in substance the interests of the company and the interests of the shareholders are identical, and the shareholders are entitled to maintain the petition. The court rejected that contention, observing that what the company could not achieve directly, could not achieve by relying upon the doctrine of lifting the veil indirectly. The petitioner in this case seeks to challenge the infringement of his own rights and not of the banks of which he is a shareholder and a director, with which he has accounts current and fixed deposit. The court then goes on to observe as follows, that if your rights are so infringed to the extent that your rights as a shareholder or director in the company itself are under threat, then you are entitled to maintain action with the company. But the company by itself may not be competent to maintain an action solely under Article 19. Therefore, it is strongly advisable that the grounds available under Article 14 be raised frontally and squarely by pleading arbitrariness, discrimination, and inequality in treatment before the law. And inequality in treatment, as I've just mentioned, that by perhaps raising the argument that the government is itself deferring or denying wages to certain classes of employees, but we as private parties are being forced to continue making payments. Now, therefore, this now sort of wraps up the first part of what is the locus of organizations to challenge the law itself. So we have now crossed the first hurdle. We are now confident that yes, we have a right to go to court. Now, if we do have the right to go to court, under what basis would I make my challenge? What would I tell the court? That I don't like the law, that the law is unfair, that the law is discriminatory. The court will then say, okay, please tell us in legal terms, explain to us as to why you believe any of this above or true. So the first head of challenge that I'm going to deal with, and this will get slightly legal if someone from a non-legal background wishes for a clarification, do post a question. I will try to answer it in a simpler manner. So coming to the first question of arbitrary. Arbitrariness is an anathema to the Constitution of India. Action of the state that is arbitrary is frowned upon. Why is it frowned upon? Because the Constitution states that the state must deal with and treat everyone equally, without discrimination and without any favor. The question now, of course, arises as to how has the doctrine of arbitrariness evolved? Pre-1974, we had a very, very different conception of what arbitrariness was. Post-1974, we've had a very different conception of what arbitrariness is. There is a very famous example that is often repeated, that if there is a law that says that an offender must be boiled to death in hot oil for committing a particular offense, is that law merely because it exists on the record and merely because the government says that it is law, or whether that can be tested on any particular touchstone because the law merely prescribes a punishment, and it prescribes a particular form of punishment. But our courts have stepped in to say that no, a law is only law and capable of being obeyed only when it is just, fair, and reasonable. That is the conception that has been introduced into our judicial thought into the lawmaking process, and it is a very cherished principle that safeguards the rights of every party who claims that governmental action has infringed their rights or has hurt their interest in a certain way. So let's just sort of briefly deal with two leading cases on arbitrariness. Of course, there are many other cases. I would not be referring to them because I want to restrict myself to cases that are recent, that deal with these issues in a more comprehensive manner. The first judgment is Sharia Banu, 2017, 9 SSE, page 1. This is the triple talaq judgment. And in all fairness, it's a 3:2 decision. 3 judges of the Supreme Court have rendered A opinion, and 2 judges of the Honorable Court have disagreed with that opinion. So I will be relying on the majority opinion rendered by Honorable Justice Nariman, for which Honorable Justice Lalit has also agreed with. And I'll just briefly read out certain passages because this judgment very beautifully traces the development of the law from 1974, pre and post. I'm not going to rely mostly on the pre-1974. I'm going to speak on the post-1974 itself. And that itself is very beautifully captured in para 68 onwards of this judgment. I'm only going to read the following lines from that particular judgment, and it reads as follows. Article 14 strikes at arbitrariness in state action and ensures fairness and equality of treatment. The principle of reasonableness, which legally as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence, and the procedure contemplated by Article 21 must answer the test of reasonableness in order to be in conformity with Article 14. It must be right and just and fair and not arbitrary, fanciful, or oppressive. Otherwise, it would be no procedure at all, and the requirement of Article 21 would not be satisfied. I've just received a request to share my screen from some participants. These judgments I'm reading from the website of the Supreme Court. If someone does wish to read them, I can provide the necessary citation. Do pardon me for not being able to share my screen right away. If for the benefit of everyone, I'll just repeat what I just read. The judgment says as follows. Article 14 strikes at the arbitrariness in state action and ensures fair and equality of treatment. The principle of reasonableness, which legally as well as philosophically is an essential element of equality or non-arbitrariness, pervades Article 14 like a brooding omnipresence, and the procedure contemplated by Article 21 must answer the test of reasonableness in order to be in conformity with Article 14. Now, this is essentially Menaka Gandhi's case, right, which is the turning stone of Article 14 jurisprudence in India. Now, this was followed by the judgment of Babita Prasad, and now this particular judgment in Sharia Banu in para 70 reads as follows. That the arbitrariness doctrine contained in Article 14 would apply to negate legislation, subordinate legislation, and executive action is clear from the celebrated passage in Ajay Hasya, which reads as follows. I'm not going to read what the court has quoted, but there is a particular passage that is very beautiful in understanding what Article 14 really provides as a guarantee or the protection from law, and it reads as follows. Wherever, therefore, there is arbitrariness in state action, whether it be of legislature or of the executive or of authority, Article 14 immediately springs into action and strikes down such state action. In fact, the concept of reasonableness and non-arbitrariness pervades the entire constitutional scheme and is a golden thread which runs through the whole of the fabric of the Constitution. Therefore, this judgment is very, very clear that we can invoke Article 14 to challenge the present action of the Government of India under the Disaster Management Act and to state that, look, this is not reasonable, it is not just, it is not fair, and therefore it fails the first test under Article 14, and therefore we invite the court to strike it down or read it down in a particular way. Now, having dealt with the question of what is arbitrariness in this context, I'll now refer to specifically subordinate legislation in Article 14, because subordinate legislation is a different animal. It is not immune to the degree that legislation is. It is more susceptible to judicial review. It is more susceptible to judicial challenge. But then the basis of such challenge or review are also slightly different than from what you would employ to judge the validity of the statute itself. Now, coming to subordinate legislation and Article 14 challenges, the judgment which I would rely upon is Cellular Operators Association versus the Telecom Regulatory Authority of India. The citation is 2016, 7 Supreme Court cases, 703. For those without access to the database, the civil appeal number is 5017 of 2016, and the date of the judgment is 11th of May 2016. And you can either take it from the Supreme Court website, or as it's been suggested, we can email the citations in a while. Now, coming to the question of how is subordinate or delegated legislation to be questioned, we would read from para 34 onwards, which provides a very pithy and very skillful exposition of the law about how challenges are to be raised. And just reading that so that everyone is aware of how to go about challenging it, let me first read. In state of Tamil Nadu, this court, after adverting to the relevant case law, laid down the parameters of judicial review of subordinate legislation. A, lack of legislative competence to make the subordinate legislation. Does A exist in our case? I would submit no. The Disaster Management Act does exist. There is the competence to pass the order. So therefore, A is not a ground of challenge that is available. B, violation of fundamental rights guaranteed under the Constitution of India. Yes, this is definitely available to every single petitioner who would stand up before court and say, look, my right under Article 14 and Article 19 has been irreparably infringed by this particular action of the government. C, violation of any provision of the Constitution of India melds into B, you can raise it. D is very, very important. And D reads, failure to conform to the statute under which it is made or exceeding the limits of authority conferred by the enabling act. And F, I'm skipping E because it's not relevant again, because it's repugnancy. F now reads, manifest arbitrariness and unreasonableness to an extent where the court might very well say that the legislator never intended to give authority to make such rules. Now, this particular exposition of the law gives us two very, very clear-cut bases to challenge the action dated 29th of March. Firstly, it says that there is a failure to conform to the statute under which it has been made or exceeds the limits of the authority. Now, I have demonstrated that the order dated 29th of March does so because the enabling statute, which is the Disaster Management Act, and specifically Section 10(2) thereof, does not give you the power to requisition private resources to make payments of wages. At best, the Act gives you certain powers to requisition premises, vehicles, men, or materials, and not otherwise. And therefore, the ground under D, that it is exceeding the limit of authority conferred under the Enabling Act, is definitely available to us. Is F available in terms of manifest arbitrariness or unreasonableness to an extent that the court might very well say that the legislature never intended to give authority to make such rules? Yes. Upon a reading of the Disaster Management Act or of the Epidemic Diseases Act, can one really say that the legislature, while passing these acts, really intended to give the national executive authority to make the payment of wages mandatory? It is doubtful. It is very, very doubtful that such authority was ever conferred. And that itself forms the basis of challenge, because the failure to provide such a power itself means that the action is so manifestly arbitrary that the court must strike it down in terms of Article 14 of the Constitution. Now, having dealt with the question of arbitrariness, let's deal with another very, very interesting doctrine, which has been around for a while, but is not so often invoked, which is to state that if the statute mandates that a particular thing should be done in a particular way, then it can be done in that way only, or not done at all. Now, what does this really mean? Now, if the statute, say for example, any statute confers a particular power on a particular authority, this maxim states that the authority will exercise its power only in the manner prescribed in the statute, or should refrain from exercising that authority at all. Now, there are many, many cases that deal with this in many different contexts. Again, for the sake of currency of the law, I am dealing with a judgment that has been handed down by the Honorable Supreme Court of 10th of January 2020 in the case of Anuradha Bhasin versus Union of India. The writ petition number is 1031 of 2019, and the date of decision, as stated earlier, is 10th of January. And I'm only going to read para 106 of this particular decision. Fairly lengthy decision, but 106 is extremely beautiful. It tells us that this also forms a ground of challenge, and 106 reads as follows. We also direct that all the above safeguards, as elucidated by us, need to be mandatorily followed. In this context, this court has observed as follows. It is well settled that where a power is required to be exercised by a certain authority in a certain way, it should be exercised in that manner or not at all. And all other modes of performance are necessarily forbidden. It is all the more necessary to observe this rule where the power is of a drastic nature. Now, with the greatest respect to the order dated 29th of March, this particular expositional law assumes great significance. It has effectively trampled upon rights of private parties to deal with their employees in a manner that they deem fit, but has not done so in a manner that the statute prescribes. It has done so in a manner not known to the statute. Therefore, this particular exposition that where a power is required to be exercised by a certain authority in a certain way, it should be exercised in that manner or not at all becomes extremely important. Because as a petitioner, I'm entitled to stand up and tell the court that this authority should not have exercised this power at all, because it has not done so in a manner in which the Disaster Management Act prescribes that it should be done. Now, this also tells us and gives us a very, very important answer in terms of how we challenge this action. We are now essentially telling the court that we do not believe that the Disaster Management Act actually has this power, and therefore you must strike it down. Therefore, you are now going backwards by positing the act in light of these rules and then telling the court that we call upon you, we invite you to strike it down for this particular reason. Now, the last basis of challenge that I would raise is yet a slightly unknown, not unknown perhaps, but not an often invoked basis to challenge subordinate legislation or orders. And this essentially is the doctrine of malice in law. Malice, as we all understand, is essentially a feeling of ill will or a feeling of wanting to do something harmful to a particular person. That this, in legal terms, is known as malice in fact. For example, if I as an employer do not like a particular employee, I can fix his performance records or her performance records to terminate that particular employee. This would be malice in fact, because I am actuated by consideration that is not really relevant to judge that particular person's action. But when I speak of malice in law, it is a very, very different standard of adjudication of state action. Because when a state acts in exercise of its authority, it is presumed not to act against a particular person. It is presumed that it is not actuated by feelings of ill will or malice or by a feeling of wanting to target a particular person or a class of persons. However, malice in law is defined. And malice in law really means as follows. The state is under an obligation to act fairly without ill will towards anyone. Where malice is attributed to the state, it can never be a case of personal ill will or spite on part of the state. Legal malice or malice in law means something done without lawful excuse. It is a deliberate act in disregard to the rights of others. It is an act which is taken with an oblique or indirect object. It is an act done wrongfully and willfully without reasonable or probable cause. and not necessarily an act done from ill feeling or spite. Mala fide exercise of power does not imply moral turpitude. It means an exercise of statutory power for purposes foreign to those for which it is in law intended. It means a conscious violation of the law to the prejudice of another, a depraved inclination on the part of the authority to disregard the rights of the others, where intent is manifested by its injurious acts. Passing an order for unauthorized purposes constitutes malice in law. Now, this particular exposition of what malice in law is to be found in the judgment of the Honorable Supreme Court and Ratnagiri Power. The judgment citation, for those who wish to note it down, is as follows. 2013 1 SSE 524. For those without access to the database, the date of the decision is 18th of October 2012. Civil Appeal number 7593 of 2012. Now, therefore, malice in law in this particular case can very well be a ground to challenge the order dated 29th of March, because we do see that statutory power which exists has now been exercised to achieve a purpose which the law really did not intend, which is to direct that private parties be made liable to continue making payment of wages. And therefore, within the many grounds that we will raise to challenge state action, I do believe that malice in law is also extremely important to raise. Now, this comes to the current state of the law, where we really are at, and where do we see this entire challenge going? As many of you are aware, a lot of parties are already before the Honorable Supreme Court. In fact, the matter is supposed to be taken up tomorrow for hearing on questions that we have just discussed and deliberated upon. But what is pertinent to note is that the MSME Association from Gurgaon had approached the Honorable Court, and on the 8th of May were denied interim relief, in fact, from making payment of wages, and the matter has been now set for hearing tomorrow. This sort of gives us an indication that the Supreme Court is alive to the issue, but is also perhaps more alive to the issue of the fact that there are people in distress. And this sort of brings me to how does a court really deal with situations like this? As I began by saying, hard cases make for bad law. And I do believe that this will be one of those cases where the court will be called upon to make an extremely delicate balancing act. And where the court might go with that balancing act is really difficult to predict as on date, simply because the facts of the case are very harsh. You see, our hearts go out to each and every one of those people who are affected. And when I mean people who are affected, I go back to my legal definition of those who earn 24,000 rupees per month or less in terms of the law. They're extremely badly affected. Will the court step in to say that you're entitled to withhold their wages because you've not come to work? It's debatable. Would I like the court to come down and say that yes, the power of the NEC is in excess of what the power conferred upon it is? Yes, I would like that determination to be made by the court. And we must therefore be strong enough to fight this legal challenge, to come up with arguments that convince the court that, look, in this particular situation as well, we are entitled to exercise our rights, and stand up before the court and say that we are entitled to certain relief, because at the end of the day, you are balancing rights of not only those people who are affected by the lockdown, but also people of private employers. For example, private employers, especially those who are small scale, medium scale, or even maybe large companies to that extent, may not have the income during this period. The orders require to make payment of wages even to contractors. Now, for example, I might have a contractor whose term was to legitimately end on the 1st of April 2020. Does this mean that I cannot request that contractor to stop providing services merely because it happened in the middle of the lockdown? Is a very interesting question that will arise. If the contractor's term was to naturally end on the 1st of April, then I should be entitled to tell him, very well, thank you, but our relationship is now ended. Will the contractor then stand up and say, but look, during the period of lockdown, because of the order dated 29th of March, you cannot ask me to leave? Again, it's a question of interpretation. Which way the court might swing is very, very hard to state right now. Again, my opinion is that if it were to naturally expire on the 1st of April, you're entitled to tell your contractual employee, thank you very much, but we no longer wish to continue our association. Similarly for workers. But again, as I say, these are extremely hard questions that the court will have to consider. And we are only alive to the fact that as of right now, the only obligation that we really have is a moral obligation. And there is good reason for why I say this. Because the Ministry of Corporate Affairs, in a recently answered FAQ basis, has stated that the obligation to pay wages during the lockdown period is essentially a moral obligation. And I'll just quickly read that as to why I believe the Ministry of Corporate Affairs is sort of a guiding principle for us, because it is an arm of the government at the end of the day. And the question posed to the MCA is as follows: whether payment of salaries or wages to employees and workers, including contract labor, during the lockdown period be adjusted against the CSR expenditure of the company. The answer of the MCA is as follows: payment of salary and wages in normal circumstances is a contractual and statutory obligation of the company. Similarly, payment of salary or wages to employees and workers even during the lockdown is a moral obligation of the employers, as they have no alternative source of employment or livelihood during this period. Thus, payment of salary or wages to employees and workers during the lockdown period shall not qualify as admissible CSR expenditure. And this provides a very, very important clue as to how the government of India views the obligation to make payments. So tomorrow, in the court of law, I would definitely use this interpretation of the government of India to say that the order dated 29th of March must fail, because it is okay for you to tell me I have a moral obligation to do so, but you cannot make it a legal obligation to do so. And that pretty much sums up what I had to share with you all today. On a very, very light note, many, many years ago, Ghalib was asked, "Aap kaise hain?" And he said, "Hum to maze mein hain." And the person who asked him the question, he said, "Aise mahol mein aap maze mein kaise ho?" To which Ghalib replies in a very sarcastic manner, and he replied as follows: "Zindagi mein gum mein dard mein maza hai, aur maze mein hum hai." I believe this really tells us and sums up the state in which most employers find themselves today, that they have no option but to say maze mein hum hai. And I will now invite questions from whoever has questions, clarify any position in which I might not have been clear.
I would request all the participants, if anyone has a question, they may just pose it in. In the meanwhile, from the Facebook Live, we have one question, Mr. Deshmukh. What should be the timing of litigation? Whether one has to be proactive and go and file a writ before a high court or a Supreme Court, or they should wait for a government department to take some action, and thereafter to quash that or to challenge that, they should be moving forward.
When it comes to cases like this, let's be very clear: offense is the best form of defense. If you believe that your rights are being infringed, go to the court now. Because there does exist Section 51 of the Disaster Management Act, which makes this a criminal offense. Of course, as I pointed out during the course of our discussions, that there has to be a reasonable ground to disbelieve. But when are you going to establish that reasonable ground? During the course of trial, once summons have already been issued to you, when you're already before court? It's going to be a long, hard road at that point in time, because you're already facing the heat of the law. So if you believe that you are affected, then I would strongly advise you to go to the court today, either by way of an independent petition to the High Court within whose jurisdiction you're located, or to the Honorable Supreme Court.
One more thing, one minute. I think there is one question coming on our way. Mr. Rajaraman is asking us, are notifications are arbitrary or legally not tenable? I think the answer is yes. Would like to elaborate on that?
I would briefly elaborate on that. How do we say that a particular notification is arbitrary or unreasonable? As I said, there are bases to do so. The bases to do so are given in the judgment of Cellular Operators Association of India, and two bases are necessary in this particular case. I'll read them out again. First, that there is a failure to conform to the statute under which it is made or exceeds the limits of the authority conferred by the Enabling Act. And F, manifest arbitrariness to an extent where the court says that the legislature never intended to give authority to make such rules. So I hope that answers that particular question.
And Mr. Deshmukh, the way I have understood, when any challenge is going to be posed, I think that ultimately the deciding factor is going to be the constitutionality of the fundamental right. I think the whole argument is going to be over there, how well that has been framed. Because we know for one thing for sure, the way the courts are going to go, if immediately the hearing does happen, is more on the side of that humanity factor and all that. So it is very vital that constitutionally that petition or the challenge is well drafted and well crafted.
My advice to anybody challenging this particular notification is to say that, look, this is an excess of the powers that have been conferred on the National Executive Authority. If one were to take a very hardline view that, look, my fundamental rights are being challenged, then, as you rightly said, the court is also likely to reply by stating that, look, there are the rights of people who are actually suffering on the roads. But if you can mount the challenge by specifically stating that, look, yes, you might have the authority, but this particular action is beyond your authority, I do believe that that is a significant legal challenge which is very, very difficult for the state to justify.
One more question is coming our way. Another contradiction which the corporates are facing is that the notification from Labor Department of various states most of the times are inconsistent with the central government advisory guidelines. Which one will prevail? I think the answer is very clear. It is the center which will prevail, but I will leave it up to you to elaborate it further.
Mr. Vyas, you're right, the center will prevail. And let's be very, very clear, Section 71 of the Disaster Management Act says this act will apply notwithstanding anything contained in any other law for the time being enforced. So if you find a state government notification that is at odds with the central government notification dated 29th of March, you are entitled to tell the state government that, look, your particular notification is contradictory. But let me introduce a small caveat here. From what we have seen in the manner in which state government notifications have been working is that if the state government notification is stricter than the central government notification, then there is a little more leeway given to the state government to enforce a stricter notification. The converse being that the state cannot dilute the provisions of what the central government is trying to do.
Well summed up. I think one more question is there. Do you think that if the effect of the law, assuming it is valid, would make a company technically insolvent, then it would need to file for insolvency?
This is again a very, very interesting question that has been raised. Insolvency, will it push you to insolvency is a factual question, but I do believe that for a lot of small organizations, this will be the death knell. Quite frankly, because if I'm required to make outgoes today and I'm going to get some money in the future, then it's really a no contest there. And this brings me to an aspect that I deliberately skipped out on. There is something called the National Disaster Relief Fund, NDRF, and the National Disaster Mitigation Fund that is in fact required to be maintained by the Government of India under the Disaster Management Act. And why has the government not used those resources available to sort of either transfer the money to the workers directly or to the employers, those who are paying their workers, is a question that is still left unanswered. And very interestingly, in this light, I have noticed that the governments across the world have taken a very different position on this particular issue. Australia, Canada, UK, US have all introduced wage subsidy schemes in one form or the other, where employers who are not paying their employees are entitled to tell the governments of their countries that, look, we're not paying this section of employees and we require these employees to be paid, and the governments are in fact paying them. In the US, it's the wages scheme. In the UK, it's the furlough scheme. And in the Australia, it's the wage subsidy scheme. But in fact, the government has stepped in and said that very well, we know that private employers will not be able to pay. So therefore, we are making direct wage payments to these particular people up to a certain amount of money.
I think one of our participants, Nia, has put up a question I think has the Bombay High Court directed to pay wages as per the judgment delivered in Aligned Components Private Limited versus Union of India? I think basically this judgment, if I'm not mistaken, is as per the Aurangabad bench of the Bombay High Court. And the question is further subdivided: the petitioners to pay the gross monthly wages to the employer, save and accept conveyance allowance and food allowance, if being paid on month-to-month basis in the case of those workers who are not required to report for duties. The hearing is listed on 18th May, adjourning it by 2 weeks, and it states that the payment of gross wages by these petitioners to the workers save and accept conveyance food allowance shall be subject to the result of the petition. So I think basically this is a judgment of the Aurangabad bench of the Bombay High Court, where the matter was on a slightly different level, where it deals with a very small or a narrow aspect, where those areas where the economic activity is allowed to be conducted and the workers are not coming to work or they're refusing to work. So I think in that reference, the Aurangabad bench has passed a judgment or an order whereby they have stated that the corporates are not required to pay salary to those employees or those workers who are not coming and working.
To just sort of take that point a little forward, let's be very clear, the lockdown orders split essential and non-essential manufacturing and industrial activity as well as services activity. Therefore, for those sectors which fall within essential and permitted scope, if you have had employees or workers who did not attend, you have a very, very strong legal case to not make payments to them because they are entitled, they are supposed to be on duty because you are entitled to function in terms of the law.
Right. I think there is a next question coming from Mr. Ashish Talwar. It is a very interesting query in the sense he's stating that let's for some time keep the legality of the notification aside. In other words, he's saying let's not discuss on the legal part, whether it's a valid or a not valid. What is the notification validity? Are we technically still under the lockdown when most of the employees can actually go to work? And just as an addendum to this query of Mr. Talwar, I would like to add that when initially in the month of March, these notifications or these orders were issued by the central government, no one was aware how long this lockdown is going to be extended for, or is it going to be the new normal as such. For the worst take argument, if we have to take a logical conclusion that it will be extending for a period of 1 year, then at that point of time, I don't think any corporates would be in a position to pay it.
Okay, first of all, let's be very clear. The initial orders extending lockdowns were supposed to operate only for the specified period, which I believe was at that point in time, 25th of May or something like that. I'm not very sure, but there was a certain date on which they were supposed to end. But the order dated 1st of May 2020, again released by the Ministry of Home Affairs, is very, very clear that these new guidelines, in addition to the old guidelines, come into effect from 04/05/2020 for a period of 2 weeks. And all subsequent orders of the MHA have been extended. They are available. A lot of these notifications extending the earlier notifications are now available on the website of the MHA. If there is a particular notification that, or a specific extension of notification that you are aggrieved by, please feel free to write in to us separately. We'd be happy to answer the query on a case-to-case basis.
I think that's it for the day. I think I would like to offer Mr. Deshmukh vote of thanks. We are very fortunate that you have not only discussed the matters in length, but also have discussed entire jurisprudence, how the matter has to be taken in the court of law. With my legal background, I think I was feeling like I was sitting in the courtroom, seeing you argue out the matter. It was such beautifully, symphony was there in front of me like a poetry. So I think Mr. Deshmukh, on behalf of Udan Saluters, I extend my vote of thanks. And I'm very sure you will keep on coming on the basis of the invite we send or extend to you and share your wisdom with our participants. And I'll also request all the participants going forward in our YouTube channel, all the sessions, what we are doing, what has happened already, and in the future also what we are conducting, everything is going to be posted in the YouTube. Tomorrow we have a session on insolvency code. Advocate Chetan Kapadia from Bombay High Court is going to discuss on that. With that, thank you all.
Just before we close, a big thank you to each and every person who's taken out 2 hours of their time to sit with us today. It means a lot to us. We are grateful to you and we're thankful to you. Have a pleasant day ahead. Bye bye.